Hey there, welcome back. Today we are diving into a topic that is really important, but often a bit confusing, and that is severance agreements. Whether you are an HR veteran, you're new to the field, or maybe you're an employee that is currently facing a severance agreement, this video may help clear things up for you. So let's get started. First things first, what exactly is a severance agreement? Simply put, it's just a contract between an employer and employee that outlines the employee's departure from the company. Now, when are these agreements usually offered? Generally, you're going to see them during layoffs, individual terminations, or when there's a mutual agreement to part ways. That is more typically going to be at an executive level. They're pretty standard documents that your company's attorney can provide. And please, please, please remember, don't ever draft one on your own. Be sure to get one from an attorney. Before you offer a severance agreement, there's a few things to keep in mind. First, check if the employee has an existing employment agreement. If they do, make sure the severance agreement includes any applicable terms from that employment contract. For example, they might be entitled to a certain number of months of severance pay if they're terminated before completing a certain number of years of service. If the employee doesn't have an agreement in place that outlines the specifics of the termination, then you're good to go ahead and proceed without that as consideration. Severance agreements can include various types of consideration, such as cash payments. Now, those can be either in a lump sum or in increments. If they're in increments, it's most likely going to follow the standard payroll schedule. So weekly, biweekly, semi-monthly, or monthly. However the company pays is typically how those increments would pay. You could also include COBRA reimbursement or benefit continuation. That could be paid on behalf of the employee or as a lump sum. You might also include a bonus payment or a proration of bonus payment. It might include LTIP, which is a long-term incentive plan. It might include stock option payments, and it also might include outplacement services. Outplacement services assist employees to help them find a new job. Be sure to check if your company has a severance policy in place, and also check to see if your state has any specific state requirements as well. Now, if the employee you're offering severance to is over the age of 40, there are going to be additional considerations. You'll need to include an Age Discrimination in Employment Act clause, that's ADEA, and you'll have to provide a 21-day period for them to consider the offer. Now, if the employee accepts within that 21-day period, they're going to have an additional 7 days to revoke the agreement before it actually becomes effective. Now, for group layoffs or reduction in force, the consideration period is going to extend to 45 days plus the 7-day revocation period. In these cases, you also need to include an OWBPA addendum. Now, that is something that discloses the positions and ages of the employees that were considered for layoff. Finally, it's crucial to encourage the employee to consult an attorney. Present the facts clearly, give them the time they need, and do not ever force a signature. The goal is really for them to understand and feel comfortable with the agreement before accepting it. Now, that's it for today's very quick guide on severance agreements. I hope it was helpful for you. If you have any questions or if you need further clarifications, be sure to drop a comment below. And don't forget to subscribe for more HR tips and tricks. Thank you so much for watching, and we'll see you next week. Bye.